Iluna, please rise. Auhea o ko e ko ka aha. Nahe kuliana imua o kea aha ho o kolo kolo ki ike hano hano o ka moko aina o Hawaii. E naoi mai, e malio mai, I lohe ia ka leo. Hear ye, hear ye, hear ye. All persons having any business before this Honorable Supreme Court of the State of Hawaii, draw nigh. Give your attention and you shall be heard. E noho ilalo, please be seated.
Please call the case.
Case number SCAP-22-0000547, Ronnie L. LLANES, Sharon L. LLANES, Michael Cody, and Lauren C. Cody, petitioners, plaintiffs, appellants, versus Bank of America, N.A., Chris Edward K. Cam, Kristen M. Cam, J.P. Morgan Chase Bank, N.A., Akiko Miyazaki, individually and as trustee of the Akiko Miyazaki Revocable Living Trust dated September 7th, 2017, Mortgage Electronic Registration Systems, Inc., and High Tech Lending, Inc., respondents, defendants, appellees. Arguing for the petitioners, plaintiffs, appellees, LLANES et al., James Bickerton, arguing, also appearing Van Shima. Arguing for the respondents, defendants, appellees, Bank of America et al., Elizabeth Timmermans, arguing, also appearing Allison Mizuli. Argument on the merits.
All right, good morning, aloha everyone. Today's proceeding is being broadcast live on the Judiciary's YouTube channel as well as on Alelo. I'd like to welcome and thank our substitute justices, Judge Paul Wong and Judge Rowena Somerville. Counselor, are you ready to proceed?
I am, Your Honor.
Ms. Timmermans, okay. We've allocated 30 minutes for each side. Mr. Bickerton, you've indicated you would like 18 minutes for your opening with 12 minutes for rebuttal, so we'll give you a warning 18 minutes in. Ms. Timmermans, you have 30 minutes. We'll give you a warning with 5 minutes to go. Please proceed.
Thank you. May it please the court. I'd like to introduce today Ronnie and Sharon LLANES, who are sitting in the gallery with our co-counsel, Bridget Morgan Bickerton. This is a really big day for them and for a lot of other people. This property was the biggest investment of their life. They bought a brand new home from D.R. Horton. 2008 wasn't a good year to buy a home, but they didn't know that. And they put down the equity that they had from their first home. They had kids at the time. At the time they bought the house, they had a 7-year-old girl and a 14-year-old boy. This was their dream. Ronnie ran a fencing company of his own, and Sharon worked for Territorial Savings as a bank teller. Very typical Hawaii family. And they put their own savings and their own hard-earned money into this property. And the law protects consumers like that, protects people like that, because it says, we're going to make sure that no one sells your big investment unless they scrupulously follow the law. The law is strict. Now, I'd like to use a visual aid. I did mention it to counsel. They have no objection. And I mentioned it to the clerk, and he mentioned that he would ask your honors for permission. I will stipulate that this house is not in the record. It's a symbolic house. But what we've found in trying to explain our position to many judges is it can get quite abstract. And I think if we have a concrete illustration, it makes it a little easier. So I'd like to talk about what happens in a foreclosure. In a foreclosure, there is an exchange. And what Lima teaches us, and Santiago taught us, but it wasn't as clear in Santiago, is that in this exchange, the debtor gives the house to the bank, and the bank gives the debtor something in return, which is called debt forgiveness. I'd like to use little visual props that reflect the amounts that are put in. So we have two categories here. The first is the cash down payment that Lana has put of $67,999. The second one is their $17,000 in improvements. As a fencing contractor, Ronnie was able to obviously improve that property. It came from D.R. Horton with just gravel. He did all the landscaping, fencing, grading. And then after that, they paid monthly payments before they ran into difficulties. Ronnie was laid off. Basically, his company had to shut down and he had to take a job as a janitor. And they still couldn't make the payments. This is from the recession that we're all very familiar with. So these three items were their out-of-pocket items. In addition, the investment in this home, I'm putting the out-of-pocket items into the home. And they also got $505,000 from the bank that they promised to pay back with interest. And then they also, when they ran out of money, they accrued interest and owed the bank $49,000. So this is the debt that was invested in this home. And in the foreclosure, the bank says, we are taking this home. And I don't think they're arguing today that it was a legal foreclosure. We're going to take this without authority because we're selling it to ourselves on a date we never published. And guess what? We're going to give you back this debt, the accrued interest and the note. We're good, guys. We're going to tear it up. See you later. Now, if this happened in a lawful foreclosure, that's allowed to happen. All of this money that the LLANES has put into this property is lost. That's the risk we all take. But what this court has said is no. We're very strict about wrongful foreclosure in the non-judicial context. Why? Because you're being the judge and the jury and the executioner too. You better follow it to the letter. And if you don't, you're going to pay the out-of-pocket loss of the plaintiff. What is that out-of-pocket loss? It's this. And the way we got there is by taking everything that was invested in this property, removing the debt, and what was left in there was their out-of-pocket loss. What does the bank want us to do? The bank says, we're going to take this note and you only put in your cash, which comes to around $116,000 of your own cash. And since we're forgiving you this note and accrued interest, which are $549,000, we're way ahead of you in what we're giving you to what you're giving up. So your number is like negative 400,000 and you don't have any damages. I say, okay, wait. You got my money and I got your debt forgiveness, but who got this? What value are you assigning to that? Even in a judicial foreclosure, we have to assign a market value, fair market value under the monolim case. So what happened? That's the sleight of hand that they've pulled on all these circuit judges, including the one here, where they don't look at the value of what was actually taken.
Mr. Bickerton, are you asking us to overrule the Lima case?
Not at all, Your Honor. I'm asking you to clarify a sentence. First of all, I don't think you have to overrule a case that said 2 times it wasn't going to say anything about this issue. Judge Mulway, this is, as I mentioned in the exchange analysis, there is a subtraction that's done. Here's what I gave you, and here's what you gave me. Subtract the 2. The negative is, the difference is your damages. In Lima, Judge Mulway said in her certified question to this court, she says, I'm not going to certify the question of what the top line of that equation is. I just want to know if you're supposed to subtract the debt. She didn't ask you what from. We said, please, court, please tell her. And this court said, no, we don't want to answer that question. We're not going to answer that question. Said it twice. And then in 2 sentences at the very end, when they were just comparing how this case works with Lima, the opinion says, plaintiff borrowers receive significant value in the form of forgiven mortgage debts. This constitutes the actual value of the property received by plaintiff borrowers. Meanwhile, plaintiff borrowers' price paid for the mortgage consists of whatever mortgage payments they made. That's the sentence that we ask you to explain, because the next sentence contradicts it. The next sentence says, Santiago establishes that plaintiff borrowers' investments and special damages must be offset by their mortgage debts. The question is the only investment you make in property, if you borrow hundreds of thousands of dollars to buy it, is the only investment you make just the mortgage payments that you made?
Well, so Lima suggests that we focus on where the plaintiffs were just prior to the tort, and suggests that at that point, since the property was underwater, we might need to set off, or that the plaintiffs would need to account for that mortgage debt in establishing their damages. Is that a misreading of the case?
I think it is, with all respect, Your Honor. The reason I say is because there was nothing about being underwater in Lima.
Okay.
They said you do have to set off the debt, but let's remember who the Lima court was talking about. It was talking about the Myers. The Myers were making an argument, not unlike the one Mr. Chung made to this panel, and we're very grateful that you accepted this transfer, and we're grateful to have the same panel. We know you're familiar with these issues. Mr. Chung argued in the Stephen Wong versus AOAO Harbor Square last November. He was arguing for the whole amount of the value of the property, and that's what the Myers brief was one of the arguments that we're making, and they were saying that the debt should be deducted at some other point. Now, what this court was saying is, look, if you're going to claim the whole value of that property as your damage, then you better subtract the debt. So we read Lima and we said, okay, yeah, what we'll do is we'll figure out what the investment was and subtract the debt from that. And the bank is now saying, you got to subtract it again, a second time. And that's where, that's why they produce no damage. They don't disagree. In all of our papers, we've pointed out that under their model, nobody ever gets any damages. We filed for over 250 different property owners. Not one of them has a penny in damages under the bank's formula. Can this court have worked all these years to build this law that you've made, starting with the Condauer case, that was our case, with Hungate, with Mount, which was not one of our cases, with De La Pena, that was another one of our cases. Has the court built this body of law just to say, well, yeah, it's all wrong, but there's no remedy, and the bank is going to be treated exactly the same as if it complied with the law? That's what their formula does. So the question is, what is the top line of that subtraction in Lima? Lima got it right when it says, Santiago establishes that the plaintiff borrower's investments and special damages must be offset by the debt. It got it wrong when it said that that top line consists just of whatever mortgage payments were made. That was the sentence. And we can explain this all day to a circuit judge, and we can say that's dicta in Lima. They were just trying to explain a difference with Santiago, or why it was similar to Santiago, but they didn't, and why you have to subtract the debt. They said they would not address the top line of that formula. So you have to treat it as dicta, but you tried convincing a circuit court judge to overlook any word of an opinion by this court. They won't. And this is why we have to ask for transfer, because no other court can clarify what that means. It's important to recognize that has to be wrong, that sentence, that it's just your mortgage payments. Because what about the Santiagos? The Santiagos had a down payment of $800,000. If you literally applied that sentence from Lima, the Santiagos' damages would have been $500,000, not $1.412 million. So their other argument is, well, look, they didn't do any subtraction in Santiago. Actually, they did. They just didn't describe it that way. But we've been through the record, and there's a footnote in our reply brief where we cite you to the pages. If you read Santiago carefully, there's about $14,700 and something of debt left unpaid. In Santiago, they said that it was essentially paid off, or practically paid off, and a similar formulation was used in Lima, but no one has said it was entirely paid off. So my question is, after Justice Pollock totted up all the out-of-pocket losses for the Santiagos to the penny, he did not subtract the debt to get to the out-of-pocket loss, the $14,000 of unpaid forgiven debt. He didn't have to, because it was excluded in the first place. And that's one way we can do it here. We can just look at what we lost out of pocket. Lima says we must account for the debt.
What's your response to the bankruptcy court suggestion in the, I think it's Tirso case, that one measure of damages would be what the house could have gotten had the sale been done properly versus what it in fact was received? And I know, I gathered that that's something you have problems with, but could you explain that for us?
Yeah, I have severe problems with that. First of all, if you think really seriously about it, it's a benefit of the bargain measure, not an out-of-pocket loss measure. Those are the two measures that we use for deceit. So it's a benefit of the bargain saying, well, the bank agreed to publish a notice and they didn't do it, so let's see what you would have gotten if they had done it. And this court has made clear in Santiago that we don't use benefit of the bargain for wrongful foreclosure. We're using out-of-pocket loss. We do have a footnote, I think it's right up front in our reply brief where we address the Tirso case. But I would just point out, it's to put the burden on the wronged person to show a hypothetical auction, how it would have worked with publication, perhaps using expert testimony to get that marginal difference. This court in De La Pena said, we're not concerned with the degree of prejudice. We don't look at that. It's like, that's what strict means. In other words, what they're doing in the federal court is making a non-strict rule that basically forgives the bank, gets the bank to have a do-over, and that makes the plaintiff prove an almost impossible to prove hypothetical. And it doesn't, the other thing is, we've been told now twice or three times, if we count Manuel, that the measure of damages is an exchange measure, like a fraud case. What I gave you in this wrongful exchange, that you took my property, what did you give me in exchange for it? And the difference is my damages. Taking two hypothetical auctions doesn't correspond in any way to that. And it also looks at essentially post-tort. It doesn't restore anyone to the position. Restoring someone to the position where they were before the tort is not saying, let's imagine the tort happened and let's imagine a hypothetical version where it wasn't tortious. We've got to put you back to your pre-tort, which is the day before they held the auction. And we do that. And the bank says, oh, you don't really do that because you were underwater and it was a gloomy picture and you were going to get foreclosed. The law says we don't look at that. We look at what you've invested, because that was your pre-tort position. If you want to look at it on a book value basis, our pre-tort position, we had invested 600, the LLANES had invested 600 and I think it was 600 and, I have to go back and look at my note again. Hold on one second. I had committed it to memory, I'm sorry. $666,000 if you count everything that they were all into this. And they owed that money. That was their money. When the bank lends you money, you give it to a seller. You're not allowed to give something away if you don't own it. It's your money. But you have a corresponding debt that offsets part of the money that you've invested. That net difference is their pre-tort position. X minus Y was their pre-tort position. So we're restoring them to that. And that's why we say this argument about windfalls. This is what Judge Farris said. Oh, it's a windfall to put you back. Well, I don't have the property anymore. I put that money in, I'm getting it back out. In what legal doctrine is it a windfall to get back something I put in? Windfalls are when you get something you never had a right to. Maybe like the Myers were arguing for, like, I want a free house. Those kinds of things you can characterize as a windfall, but you can't characterize this as a windfall. So I think that I hope I've answered Your Honor's question. I come back to what really got me thinking about that sentence in Lima was reading 6 weeks later the sentence in De La Pena that says, look, we've decided not to let you get back the house as easy as you could under Silva. Under Silva, we automatically would just get it back. We're not going to do that. We're going to make this voidable. We're going to make it, you got to prove they've got to prove they're bona fide purchasers and they can keep it. The new buyer can keep it. And the reason that we're doing this is because our damages remedy provides a deterrent. That made me stop and think. I said, well, look, if Lima is correct in that sentence, that's not going to deter one bank ever from anything. So what does the court mean? And it made me go back, and then because Lima keeps saying, look at Santiago, look at Santiago. And Lima clarified something that I hadn't seen. I didn't know how Judge Pollack did the out-of-pocket calculation. He did it without showing it, and then he described how it works, talking about the deceit tort a few pages later. He didn't say, I used this same model to calculate the wrongful foreclosure damages. So we weren't really sure, but Lima told us that they are one and the same. This exchange model is one and the same. So we respectfully submit that the court should take another look at that sentence in Lima. It's not a question of overruling when the Lima court assured us that it wasn't going to address that sentence. It's pure dicta. And so I do think it can be looked at, and it's causing havoc because it means nobody has any damages for this tort. We are now in a situation, we saw the stock market drop this week. I know from having read the cases that even in the 1800s when we had these kind of cases, they came from cyclical economic depressions, bust and boom. We still have those. We have not managed to use technology to get ourselves out of that. And so as sure as day follows night, we will have another bad economy. And there will be waves of recessions, or people in Kona, their fencing companies have to shut down because there's no work and they'll miss their home payments. And the number of foreclosures will be so large that circuit judges can't handle them, and they will return to use the non-judicial method, which is still on the books in Part 2 and still being used every day by condominiums. So we have two types of non-judicial foreclosure still on the books. So this is an important ruling. We ask the court to really take a hard look at that sentence in Lima. Our briefs address it, we think, very well, and we have some very good illustrations of the kind of ridiculous results that the bank's formula produces, and we ask the court to take a look at those as well. Unless there are other questions, I'll reserve the rest of my time, which I think is about 10 minutes now. Thank you.
Thank you, Mr. Rich. All right, Ms. Timmermans, your argument.
Good morning, and may it please the court. I'm Elizabeth Timmermans here on behalf of Defendant Appellant Bank of America. Defendant Appellee. In order to adopt the plaintiff's damages model before the court today, this court must absolutely overrule Lima. Less than 2.5 years ago, this court already rejected plaintiff's same arguments that they are making here today, knowing that the decision would be dispositive of the Lima case at summary judgment. In this case is Lima. This case involves two properties where there is no dispute that the plaintiff borrowers defaulted on their mortgages, they could not repay them, and the bank hired Hawaii licensed attorneys to perform non-judicial foreclosures. Like the plaintiffs in Lima, the plaintiffs here bring claims for wrongful foreclosure and violations of Hawaii's UDAP statute, alleging not that the bank didn't have the right to foreclose, but that the Hawaii's attorneys did it in a deficient manner through postponing the sales. Plaintiffs claim that Lima did not provide full guidance to make a decision today, but it did. This court decided that plaintiffs have the burden of establishing compensatory damages that put them in the position immediately before the wrongful act. And here, that is the allegedly deficient foreclosure. And that is to survive summary judgment. What plaintiff's calculation does is put them not in the position immediately before the foreclosure, but in the position they were before ever entering into the loan and ever purchasing the property. It returns every single dollar that they spent. What plaintiffs are doing is a calculation that's simply contrary to Lima. To eliminate the impact of the forgiven debt that this court said they must account for, they just add it to the top of their equation. Then they subtract that same number to always get themselves to damages. You could have a plaintiff who spent $0 on a down payment, $0 in mortgage payments, and under their calculation, when you add in loss of use, that plaintiff would have damages. That is simply contrary to Lima.
You know, what they're saying that, well, there's maybe other situations in the 0-0 situation you just described. I think what they're saying is, hey, look, there's never a situation where a plaintiff will ever be able to recover damages, and therefore, you know, what's the deal with the deterrent effect? I mean, there is no deterrent effect to wrongful foreclosures if they can never recover. Essentially, they're saying, hey, look, there's bank robbery, there's wrong without a remedy. You always win. How do you respond to that?
Well, that's simply not the case. And here we're looking at these two specific plaintiffs, if they set out their damages, and they simply didn't under Lima. I can't hypothesize on every model that they might present to this court.
Maybe, okay, I'm sorry to interrupt you. Can you hypothesize on this? When would you win?
Well, I believe that there are.
When would not you win? Describe a situation when you would not win.
I understand, Your Honor. So they set forth a chart in their briefing that shows under the Santiago model that this Lima court acknowledged and approved of, that after a number of years they would win. They have also won before Judge Ferris in the bankruptcy court. And what they did there was they alleged at summary judgment that the value of the property was worth, the distressed value of the property was more than the outstanding debt. They survived summary judgment in that case. And Hungit does allow for that sort of equitable damage. So they keep saying that this is our model that we're presenting to the court. We're not presenting a model to the court. We're just telling the court that the model they have presented does not comply with Lima because it returns them back to before they purchased the property, which is a windfall. It returns every dollar they spent.
How do we harmonize Santiago and Lima?
Absolutely. So this court in the Lima opinion, as counsel noted, walked through the Santiago opinion. And the Lima court did that because Judge Malway asked, does Santiago stand for the proposition that we don't have to account for the debt? And this court said absolutely not. And what the court did at first was contrast the two cases, distinguish them. Santiago is a case where there was fraudulent inducement at the origination related to sewer costs. There was no power of sale provision at all. There was no default, and there was no debt. So Santiago court, I went and I looked and I listened to the oral argument there and read the briefing. The Santiago court was very concerned with the fraudulent inducement at the origination, and also how the seller sold the property when there was no default and no debt, and then pocketed the sale proceeds. So you've got someone who's selling, keeping all of the money from the Santiagos, and then is keeping all of the funds from the sale. And what Santiago did was say, okay, in this situation, we're giving the down payment that you actually paid. We're giving the mortgage payments you actually made, your closing costs and your property taxes. And notably, what was not included in those damages was the full purchase price. Now in the Santiago's case, because they paid off the note and they paid the interest on the note, that ended up being more than the purchase price. And plaintiffs claim that this court's analysis of Santiago was somehow incorrect. But contrary, and they claim that there was debt remaining in Santiago. But the court in Santiago at page 158 of that opinion was very clear about what the calculation was, and it was amounts that they actually paid. And there was no debt in the top line, and there was no debt the bottom line because there was no debt. And this court in Lima at page 469 of Lima said the Santiagos had no remaining mortgage debt to disregard. The plaintiffs also claim that there's this inconsistency in the last paragraph of Lima about price paid versus investments. And the court was very clear that price paid was what they actually paid, just like in Santiago, what they actually paid. And then this reference to investment, counsel acts like this must be something totally different. I went to their briefing in Lima, and at page 5 of their brief, they say, I quote, plaintiffs made personal investments to purchase and maintain their properties. All plaintiffs made monthly payments on their loans. Some also gave substantial down payments. Others built, renovated, or landscaped their properties, and all paid property taxes and insurance. So the word investment there was exactly what Santiago was saying, exactly what Lima is saying, what they actually paid. So there is no discrepancy with the court's language there. And so this court looked at Santiago to say, yes, that is the measure for out-of-pocket damages. It's what you actually pay. And then you look at what the remaining debt is, and you compare those numbers. And they say that's the model they're using, but it's not. They're using a model that puts them back in the place they would be if they never purchased the property. For that reason alone, this court can affirm the circuit court. It does not need to provide an advisory opinion. Excuse me.
I'm sorry, Ms. Zimmerman.
Yes.
I don't mean, sorry for the interruption, but if we go back to where the LLANES never bought the property, right? They would have never had these improvements that Mr. Bickerton is talking about. Right? And so how do we account for that? I mean, if we're really gonna get to the point where they never purchased the property, why would they spend the $17,000 in improvements?
Your Honor, and that is a situation where if the borrowers were claiming, the plaintiffs were claiming that they made these improvements and that added to the value of the property, that could be a situation where, like in Hungate or in Terso, you say, I spent money and I improved the property. Even in an arm's length transaction, just because you put improvements in the property, you may not realize that back. And this court in Lima said it is the plaintiff's burden to establish that. And here they're asking for every dollar back that they spent. You could have a situation where someone spent money tearing down a house. Of course, that would hurt the value, but they would claim, I get every dollar back. It is their burden to establish that the distressed value of the property at the time of the foreclosure is higher than the debt, if they want to go that route, the Hungate route.
Thank you.
And we heard a bit about the burden. And plaintiff's counsel, I believe, said, no, it can't be the burden of the wronged party. That is exactly what Lima said. In numerous places, the court confirmed that it's the plaintiffs, not the defendants, who bore the burden of proof of all necessary elements at summary judgment, including damages. It was the burden of the plaintiffs to establish compensatory damages. It was the burden of the plaintiffs to account for the debt. What is the debt? And was there a deficiency? And the court walked through the Myers example on deficiency versus no deficiency. And we're hearing the same argument again and again about this burden, but that is settled law for this court. And I was a little baffled when I read the plaintiff's briefing at the last page. They said, this court was clearly just analyzing federal summary judgment law. I went back and I read Lima, and there's not a single quote to federal law on this MSJ standard. And so the court was, of course, analyzing the Hawaii standard, and it would have been inappropriate to do otherwise on a certified question.
What's the bank's position about the Tirso suggestion by Judge Ferris and Tirso that a proper measure of damages would be the difference between what the property could have sold for had the foreclosure been done properly and what in fact it did sell for? Excuse me.
Well, I don't view Hungate, Santiago, and Lima as inconsistent. I could see a situation where a borrower did make some sort of argument as to what the distress value of the property was compared to the outstanding debt. That has not been done here.
That's different from what I just asked you. In other words, you're saying they should argue the distressed value of the property exceeded the debt, correct?
Either the sale price or the debt. So whatever they say the property should have sold for would have to be higher than what it did sell for and the debt. Because if there's still a debt that's higher, there would be no damages, even if they claim that the property or the sale price should have been a little higher.
So what it should have sold for has to exceed the sale price
And the debt.
debt.
And
You know, wouldn't they, aside from that, and I think Judge Ferris was talking about, let's tether the remedy to the wrong, and that's what he was using. But what about loss use? I mean, isn't there a gap there where at least a wrongfully foreclosed plaintiff would be entitled to a chunk of time when they should have had the property, they didn't have the property, and they should be entitled to that loss use?
well, and I believe Judge Ferris did address this, saying loss use does not really account for the alleged harm. Again, it's not that the foreclosure occurred, but that the bank's attorneys did it in a deficient manner. And so they had no right to the property if there's a valid foreclosure. And ironically, what the plaintiffs are arguing is that the bank should not have postponed it and should have foreclosed earlier. And so both sets of plaintiffs here were on the property 12 months, 15 months after the default. And so they set forth these loss of use calculations. I will note there's no justification for the amount of time. There's no justification for the amounts. We're not clear where that came from, but that would ignore the harm. The harm is that they claim they should have been foreclosed on earlier than they were. There should have been no postponements. And
Well,
so,
but it's the bank that really controls when there's a foreclosure action. And the fact that the bank waits, I mean, why does that matter?
well, it wouldn't put the borrowers back in the position they were before the foreclosure, whenever the foreclosure took place. So by giving them loss of use, you are not acknowledging the nature of the harm, which is that you had the right to perform the foreclosure, but you did it in deficient manner. And that's very different than the Krog case and the Fukita case. The Krog case dealt with people who wouldn't leave the property for the new owner to have exclusive use of it. And so they were deprived of the property. So the loss of use stemmed from that wrong. And then in the Fukita case, there was a claim that the lien itself on the car was invalid. There's no claim here that the lien was invalid. They just claim that the foreclosure was done in a deficient manner. So by giving loss of use, you would ignore the nature of that harm.
Do you think that those non-property related types of cases really even apply to this situation?
I don't. The Fukita case, for example, with the taking of the car, I don't believe that that works in this scenario. And part of the reason is what I just discussed. The nature of the harm has to be considered. And as Judge Ferris noted, and all of the judges to consider these issues have noted, that would be a windfall to the plaintiffs who were in default, who could not pay their mortgages, and who were subject to foreclosure.
If the bank had done a proper, let's say, a judicial foreclosure, it could have actually pursued a deficiency judgment.
I'm sorry?
If the bank had actually gone through a judicial foreclosure process, could the bank then have sought a deficiency judgment?
I believe that that does depend on the amount obtained there.
Right, assuming that it sold for less than, at a foreclosure sale, it sold for less than the amount owed.
I'm
then
aware. I'm sorry.
My experience is that the banks often do seek deficiency judgments whether or not they can collect on them.
That's right, Your Honor. I have been involved with cases where deficiency judgments were obtained, and then there's a decision later, do we actually work to collect on that judgment?
Should we be looking at the law of other states that set out how damages should be measured in wrongful foreclosure actions?
I don't.
Actual or compensatory damages?
Well, I don't think that the court needs to when it has Lima, where this court set out very recently the goal, the burden, the time period to look at. And to the extent Your Honor is referring to the California cases that are cited by Mr. Bickerton, I will note that every single one of those cases is a fraudulent inducement at origination of the property sale or origination of the mortgage. So the goal there was for the court to unwind the entire transaction. And that was proper in those cases. But here, that is not the proper measure of damages under this court's jurisprudence in Lima.
Was that fraudulent misrepresentation pronged to the California cases analogous to the Santiago situation?
There are some analogies between the Santiago case. Again, this court acknowledged the fraudulent inducement at the origination. And the court there, in listening to the oral argument, was extremely concerned about that, the sewer fees. And so the court said in this case, the fraudulent inducement damages and the wrongful foreclosure damages where you've paid everything and there's no debt that could be accelerated, those ended up being the same in that situation. But that is a very different situation we have here where the borrowers were in default and they could not repay their mortgage. So putting them back into the position where they were before the foreclosure is very different than the result in Santiago.
Is it your position that Lima forecloses us from giving unjust enrichment or other types of damage that, for example, would reflect the increase in value that presumably flowed from the $17,000 in improvements?
Yes, this court was very clear that it has to be compensatory damages, which could include special damages. And those special damages would flow from the harm of the foreclosure itself, the result of the foreclosure. And so an unjust enrichment claim much like the restitution damages that were rejected by this court as not measurable for torts, those would be foreclosed under LEMA. We're looking at, can they establish compensatory damage to restore them to where they were before the foreclosure?
But Lima said, according to Mr. Bickerton, that there were a whole host of issues that we weren't addressing. Would this be one of those issues that we weren't addressing, so it's still an open question?
No.
If so, what's the right answer?
Right. And so, no, this court made clear that they had to be compensatory damages. It was very clear. Unjust enrichment, restitution, those sort of equitable measures were not appropriate for these tort claims. And this court, I've heard repeatedly in the briefing and in the arguments that, Lima didn't really do much. Lima did everything that the court needs to affirm the circuit court's order. It established the timing of the calculation. It established the burden. The plaintiffs must meet their burden. It also acknowledged that there are many cases where a borrower or a plaintiff may not be able to establish harm. This court said that any party seeking damages is precluded from any recovery if the value of the property that he or she received in exchange equals or exceeds the value of the property parted with by him or her. And this court noted the long line of cases that a party does not sustain any injury in such an equivalent or beneficial exchange. So when I was reading the briefing about the negative number that results when you take out the forgiven debt as an out-of-pocket expense, that just can't be right. This court acknowledged that might be a beneficial exchange for the borrower, or it could be zero in an equivalent exchange. And so the circuit court wasn't adopting a model. Bank of America is not adopting a model. We are telling the court that under Lima, what they've presented to the court does not meet their burden. And this court does not need to make an advisory opinion to tell them, going forward, this is what you need to do. The court was asked to do that in Lima and said, no, we're not going to do that. We're going to decide on the facts in front of us. And the court can do that today to affirm. It need not say, here's your guide for going forward.
So why is it that unjust enrichment is absolutely precluded in this case?
Well, this court was very clear in Lima that equitable damages like restitution and unjust enrichment are not on the table to survive summary judgment. It has to be compensatory damages.
Actual damages.
Actual damages, yes.
Santiago talked a lot about equitable principles, though, didn't it?
It did. And as I noted to this court, going back and looking at Santiago, there was that additional issue related to inequities at the sale. There was the fraud and the deceit related to the sale and the origination. And this court was very concerned about that. And there were discussions of equities in Santiago in relation to those origination-based claims. Those are not before the court. They've never been alleged. There's no claim that the lien itself was invalid, that the bank tricked them into purchasing the property or getting the mortgage. There's no evidence in the record of that. What is in the record is that they have defaulted on their mortgages. They were subject to non-judicial foreclosures. They claim those sales were procedurally deficient, not that the foreclosure should not have occurred. And so the nature of the harm is very important. It was in Santiago and it was in Lima. And again, this case is Lima. These plaintiffs claim that they were members of the putative Degamo class, which was a federal class action against Bank of America. That case had been dismissed before Judge Malway on other grounds, before Judge Malway certified the question with the 3 putative class actions. So it's very possible that if that had not happened, Bank of America, that Degamo case would have been part of the certified question as well. And these plaintiffs claim, apologies, that they were part of that Degamo putative class, which was identical to Lima. I will note as well, this court rejected nominal damages in Lima. And that's very important because what the plaintiff's damages model here does is ensure everyone will have damages, no matter the beneficial exchange. They say their model is saved funds plus borrowed funds minus borrowed funds equals saved funds. And then they add in loss of use. So as I noted before, someone paying $0 on the down payment or the mortgage payments, once they add loss of use, they could win. And that is an absolute end run around Lima. So the Lima opinion did a lot. It provided a lot of guidance. It told the plaintiff's counsel everything they needed to know to succeed. And they have decided to ask this court to turn Lima on its head. Because they are seeking a remedy that puts them back not before the foreclosure, but before they purchase the property, Lima bars their claims. And this court should affirm the circuit court order.
Okay, so sorry to keep coming back to this, but examining that aspect of Lima that you say precludes them from unjust enrichment, is that a holding or dicta? Why can they not also claim, wholly apart from their tort claim, we were wrongfully foreclosed on, there was an unfair and deceptive trade practice, and by the way, we spent $17,000 improving this property, which these folks, the bank, is now going to benefit from. Why do they not have a claim for that under Lima? What's the rationale?
So under Lima, one of the elements of damage was to claw back the purchase price that the banks received at the foreclosure. And this court said, we're not looking at any alleged benefit that the banks received. We are looking at any harm to the plaintiffs. So Bank of America, to the extent there was anything in the record on this, which there is not, to the extent that $17,000 in improvements somehow created a benefit for Bank of America, Lima was very clear that that's not what we're looking at. We're looking at putting the borrowers back into the position they were, not trying to pull some or all of the funds back.
That's the tort theory. I'm asking if there's a contract or a quasi-contract theory or other theory of recovery that Lima didn't preclude. That's my question.
Right, and Your Honor, I'm sorry if I'm not being clear. I believe Lima limited the damages to survive summary judgment to actual damages, compensatory damages, harm to the borrower. This court said no restitution. We're not looking at what happened at the sale for the bank or any other party receiving some sort of unjust enrichment. Now, if the plaintiffs believed that that $17,000 created equity and that could be harm to them, Hungit allows there to be a lost equity argument. They have not presented that to this court. There's nothing in the record saying, I made those improvements and the equity increased beyond the debt because of that.
That's how it would be picked up in the bank's perspective. In other words, the property is worth more. It was worth more than it was sold for, and it was that amount that it was sold for plus the debt is what it, no, I'm sorry, try again.
The amount that it was sold for has to be, or that they claim it should have sold for, should be less than what it actually sold for and less than the debt. Because if there's, say for example, they say it should have been $17,000 more, but the debt is still higher than that, then there's still no damages, no compensatory damages.
From a policy perspective, what's your answer to Mr. Bickerton's argument that there is no or only very limited incentive for the banks to follow the rules that were set forth in the statute for how foreclosure should be done under the rule you advocate for here today?
Well, Lima analyzed that exact issue. Incentivize versus deter showed up repeatedly in that briefing. It showed up in the Lima decision. And what the court said is, and what Judge Ferris said is, that is impermissibly collapsing compensatory damages and punitive damages. You have to show compensatory damages. And before we talk about punitive damages. So the Lima court rejected that straight out, very clearly in its opinion. And that's at page 465, 466 of Lima. So the court analyzed that 2.5 years ago and rejected it. Judge Ferris and other judges considering it afterwards have similarly rejected it, saying it's improperly collapsing. And I will note that the Hungit and Della Pena quotes that we've seen repeatedly in the briefing just stand for the uncontroversial opinion that the risk of a lawsuit and money damages can act as a deterrent. Hungit has made clear that these claims will survive motion to dismiss for the most part. And so you're in discovery, you're getting to summary judgment. I mean, those sorts of, that's part of the natural deterring of these lawsuits.
In terms of damages, isn't it affected by the theory that is raised? Here we're dealing with wrongful foreclosure, which is a tort. So we would be addressing tort damages. And a 480-2, which requires damages before you get to the minimum and the fees, et cetera. Santiago was not a wrongful foreclosure case. It was a negligent misrepresentation case in which pecuniary losses caused by reliance on negligent misrepresentation are recoverable. So it seems to me that we're comparing apples and oranges here. And it seems that unjust enrichment, et cetera, is really a theory based on breach of contract. And we're not dealing with a breach of contract case here. We're dealing with the theories of wrongful foreclosure and then 480-2, which requires some
Absolutely.
damages.
Your Honor, and this court in Lima was very specific about contrasting the two cases, both the claims, the alleged harm from them, and saying, we're discussing Santiago to answer the district court's question about whether there needed to be accounting for a mortgage. And this court very clearly said yes. So Your Honor is correct. The Santiago court was very concerned about the fraudulent inducement, the negligent misrepresentation related to the sale and the sewer.
I have a question. You know, it seems like other states, for example, Texas or Georgia, in terms of damages for wrongful foreclosure, they say the measure of damages is the difference between the value of the property in question at the date of foreclosure and the remaining balance due on the indebtedness. In other words, the equity, if there's any equity in the property. I'm wondering, how does our formulation in Lima differ from this?
Well, I do not see Lima as foreclosing that possibility. The Hungate court talked about lost equity, and lost equity would account for the debt. So that I don't see that they conflict. This court analyzed Santiago and that out-of-pocket measure. Hungate references another measure. The plaintiff's allegations relate to chilled bidding and a lower price. So Hungate and Lima, I think, can be read hand in hand as lost equity that would account for the debt. Now, again, in Hungate, it has to be the distress value of the property at the time of the foreclosure, not the fair market value at the time of the foreclosure. The Hungate court recognized that an asset in default and getting ready to be foreclosed on is a distressed asset.
Is there any evidence in the record about, I know that the bank's position is this property would have been foreclosed on, but in terms of lost use damages, is there anything in the record to establish how much longer it would have taken for the bank to do the sales correctly or pursuant to the statute?
Well, again, they claim that we should have done it earlier. There's not anything in the record about if the sale was unwound.
I hear you when you say that, but I think they're saying I would say they would claim you should have done it right, whatever the right is. I think that's what they're saying. They're not saying do it earlier without improperly, or you didn't do it right the first time. So how long would it have taken to get it right? Is that in the record?
Well, I do want to note that we do not concede that we did it incorrectly. The publication was online. I just want to note that.
I understand.
But
yeah.
to the extent there was a defect in the foreclosure, I don't believe there's anything in the record saying it would take X amount of time for us to redo the foreclosure. There's also nothing in the record to support how long they claim it would, the plaintiffs claim it would take them to get a new property, the basis for that, and the amount that they're claiming for the lost rent. So that loss of use, they have not met their burden on that piece.
What if, you know, it wasn't so far apart? In other words, the debt owed by the plaintiffs wasn't so enlarged, and that in that time frame, they could conceivably come up and cure their debt, and therefore make good on what they owed and bring themselves up to date. How does your argument finesse that situation? In other words, maybe the LLANES have in that period of time, they inherit, you know, $500,000 and are able to somehow get back on track. But because there was a wrongful foreclosure, they're out of luck. I mean, can you address that situation?
Well, to be clear, I'm not aware of a case where that situation has happened and a foreclosure proceeded, other than Santiago. And Santiago is that case. They cured the default, there was no default. And so in that case, I think there could be a question if there is debt outstanding, is there debt that has been accelerated after a cure?
But the property would have been gone, and theoretically, they would not be able to cure it, right? I mean, say there's a wrongful foreclosure, it gets sold to someone else, a third party. The next day, they come into a bunch of money.
Oh, I apologize. I may have misunderstood. I thought Your Honor was saying that in this hypothetical situation, they had cured the debt before the foreclosure?
I sort
cured
of
the
did,
default?
so yes, but say this other situation then.
So the foreclosure has occurred and they
Yeah.
have money? Well, at that point, the foreclosure is complete if the foreclosing entity still has possession of the foreclosure. I've seen situations, this is not this case, I've seen situations where there have been post-sale cures and there have been unwinds, there have been negotiations between the parties. And I think something like that could be possible. I have not seen that in any of these cases or any such allegations. Once it goes to a third party, at that point, it's the damages models that we are speaking about today.
Well, anything further for the court at this time?
No, thank you very much.
All right, thank you, Mr. Mertens. Mr. Bickerton.
Thank you. Addressing something Justice McKenna said, I would respectfully differ with you on Santiago. It was two separate discussions, and there definitely was a conclusion that it was a wrongful foreclosure. The court analyzed whether or not there was an actual power of sale in that case, and they concluded that the language of whatever Mrs. Tanaka was relying on was not adequate to provide a power of sale, and therefore there was a wrongful foreclosure. They did the analysis, came up with the number, and they said, turning now to the deceit claim, let's do an out-of-pocket analysis for that. And, oh, we've already just done it for wrongful foreclosure, so it's all captured in that, so we're not going to redo it. That's the end of the case. Now, I could see where people would say, well, that was a very unique case. It was unique. I mean, they practically paid off the loan. I definitely urge the court to read the record. You'll see they had not paid off $14,000 in debt. The bank doesn't want you to know that because then they'd have to explain why it wasn't subtracted from their out-of-pocket expenditures. But we have more law after Santiago. In Mount, this court said, you must go back and decide which Santiago remedy applies. Remember, the law is if the wrongdoer still has the property, the remedy is return. The classic remedy is return of title and possession. And that's actually what the restatement 927, which came up in the Chung case, Mr. Chung's case, the restatement 927 makes it clear in a comment that the damages remedy only arises when the right to cure has been completely cut off by transferring it to someone else. We call it making it impracticable to get the property back. Now damages are your remedy. So Mount told us we're looking to Santiago. Mount was a defaulting borrower, just like Lima, just like the LLANES, just like the De La Piñas, just like Mr. Hungate. And then in the Hungate case, the court said, yes, you are entitled to your out-of-pocket loss per Santiago. Told us that again. Then Lima came along and said, yes, Santiago teaches us all these things. So to suggest that we can learn nothing, that's the only case. One of our problems with the federal judges, like Judge Farris, is they don't do any eerie analysis at all. They don't try to predict how you will rule. They don't cite any cases. They just say, oh, this case is distinguishable from all those cases, so we'll make up our own rule. The rule, there was a question about the rule that Judge Farris uses, what I call the hypothetical auction model. I will note that is what the UCC uses for commercial situations, for businesses. You got to prove how it would have turned out. But for consumers and consumer goods, the UCC recognizes that that's not going to work for consumers. And the UCC says you get back all your interest paid plus 10% of the price, which is essentially the down payment. Just what we're talking about here. Give them back their interest payments and their down payment. The UCC will give you that if the bank takes your washing machine, but apparently, according to the bank, not if they take your house. So we do urge the court to take a look at that. I also heard reference to cases from out of state. And we cite the California cases that it is a little counterintuitive, this idea that, oh, you can put the debt in the top line and the bottom line. But I want to stress, the top line is invested debt only. The bottom line is forgiven debt. And not in every case, that is not the same number.
You
If
know, Mr. Bicknell, I was curious as to your phrase invested debt.
Yes.
Where did that come from?
It's my use of when I put the money into the house. I borrow $500,000.
No, I understand.
I'm investing it in the
I
house.
understand that, but
Yes.
the phrase itself, is that your phrase?
That is our phrase to explain it because they come back, oh, it's magic and hocus pocus. You're putting it on both sides of the equation, so of course it goes away. And we say, well, not quite, because in some cases it doesn't all go away if they're different numbers. And we stress, we are only counting the investment on the left side or the top line, only the investment. So if you borrowed money and pocketed it like a cash out, that's not going into that top line. The top line, Santiago says, and Lima repeats it, your investments go on the top line. That's the question for you. What is the investment when you buy a house? I want to close with a hypothetical. The hypothetical is you weren't in breach of your mortgage at all. You just put $100,000 down on a $600,000 property. And for whatever reason, a snafu, the bank forecloses and does it unlawfully. Ms. Timmermans will tell you that you still owed the bank $500,000, and we take that 100 minus the 500. Wow, you're negative 400 on this. So we can keep the house and you have no damage. Now, this could happen to anyone. I think all of you probably have mortgages.
But isn't that more the Santiago situation? The hypothetical, if I understand what you're just positing, is no right to foreclose whatsoever, which is Santiago.
And that is an important point to understand. This court does not distinguish between those. We are strict in Hawaii, and that's why we don't follow Texas and Georgia. We have a tradition. This tradition came from the 1800s because all the land that the king gave the commoners ended up being taken by the merchants and the elite through loans. People didn't understand what a loan was, and all of that property was foreclosed. And we've attached that, cited that work by Professor Stauffer that explains. So this statute has a long history, and the court has had to deal with it. And we have our policy and our law here in Hawaii, which is you want to go out and do self-help. You don't want to come and ask a judge. We are going to be strict. We're going to treat the most trivial violations as seriously as the most serious violations. And the damages measure is going to be the same. Now, is it a windfall? No, it is not. The windfall is a bank getting to break the law and getting treated the same way as a bank that scrupulously followed the law. To give back these folks what they put in the property. So they're still renting today. These are family who owned a home, who wanted in their 50s. They'd like to get that money back that they sunk into this property that was taken from them unlawfully and start over, but they can't. We respectfully urge this court to correct that injustice. Thank you.
All right. Thank you to both of our attorneys for your arguments today. The court will take this matter under advisement.
E ku iluna, please rise. Kua ho'oku ia mai ne kea aha ho'okolo ki ike hano hano o ka moko aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.